From the Court of Appeal of the Eastern Caribbean Supreme Court, Dominica, hearing of application in CCJ application DMA-CV number 2 of 2021 between Glenroy Cuffy, Dwayne Oswald George, Atherley Robin, and Melissa Skerrit, Ian Anthony, Josephine Lewis, Gerald Burton, Hilary Shillingford, Wayne James, Kondwani Williams, Alec Lawrence, Dominica Broadcasting Corporation, Roosevelt Skerrit, the Attorney General, and the Commissioner of Police. The members of this morning's panel are Mr. Justice Saunders, President and Presiding Judge.
Good morning, everyone.
Mr. Justice Witt.
Good morning, Counsel.
Mr. Justice Anderson.
Good morning, Counsel.
Madam Justice Rajnatley.
Good morning, everyone.
And Mr. Justice Jamadar.
Good morning, Counsel.
May we have the appearances, please? Thank you.
If it please your honours, I am Alair Shepherd, and I appear for the applicants in this matter, and with me is Zaida James and Najma, Reese. Your honours, I have in fact already said to your clerk that Ms. James will be carrying the arguments this morning. Thank you, Your Honours.
Yes, thank you. Yes, for the respondents.
Mute.
May it please you, my Lord President and Honorable Justices of Appeal. My name is Lennox Lawrence, and together with Jody Luke, we appear for the first respondents. We are led by Senior Counsel Anthony Astafan in this matter.
Yes, Mr. Lawrence. Ms. James, are you ready to begin?
Yes, thank
Your
you.
Honor, please. There's certain more appearances to be made.
Oh, I'm sorry. Yes.
Please.
Yes, sorry. Go ahead.
May it please your honors, my name is Heather Felix Evans, and I appear for the respondents. Since they are not numbered, I will have to call their name: Ian Anthony, Josephine Lewis, Gerald Burton, Kondwani Williams, and Alec Lawrence. Thank you, your honors.
Okay, thank you. Are there other counsel for other respondents?
There are, Lord President. May it please your honors, my name is Levi A. Peter. I appear with Mrs. Vanica Sobers Joseph and Miss Nadira Lando. We appear on behalf of the 10th, 11th, and 12th respondents.
Suniwadi Asaban.
Yes. Are all the respondents now? Have all the respondents now entered an appearance?
Yes, my Lord.
That's correct. My Lord,
okay, so the point
my Lord, Mr.
Yes?
President, I'm on. With the help of Mr. Aki, I was able to get on.
I see. Okay. The point I was making earlier is that we expect that the respondents would have suitably divided up the speaking time among themselves so that in total it does not exceed the allotted 80 minutes, because that's the time we have allotted to respondents' arguments. Ms. James, are you ready?
Yes, Your Honor, I'm ready. Thank you.
Okay.
Your Honors, good morning. I'll say my name again because I know it's a bit difficult. It's Zaida James, and thank you for hearing us this morning. Your Honors, we intend for the most part to stand on our written submissions, and we will use this time this morning to really highlight what we say or what we think are the most salient points with respect to the application. And of course, we will answer any of the questions from the panel. Your Honors, I want to make it clear that we understand completely that we are not, our application is not, we're not here to argue the merits of the substantive petitions that brought us here this morning. We understand quite clearly that we are arguing a point of jurisdiction, and specifically whether the Court of Appeal was correct in making a determination that it did not have the jurisdiction to hear the appeal that came before it on these issues. And very specifically, we are arguing, my lords, that the decision of Justice Glasgow, that's the subject of this appeal, was entirely and completely a final decision in every definition of a final decision. And for that reason, the Court of Appeal had the jurisdiction to hear our appeal, Your Honors. And that is the essence of our case. We believe, Your Honors, or it's our submission, that it's extremely important that this court clarifies the law on the issues raised in this application. We are concerned that the position of the Court of Appeal could potentially have confused the issues as to when a matter is final, when a matter is interlocutory, and importantly, how we treat election petitions, and even more specifically, how we treat strikeout applications on election petitions. Our submissions is that the Constitution of Dominica does not prevent a court or any court from determining that this matter is final or interlocutory. That question has always been left for the courts. And when we appealed to the Court of Appeal and this court to determine that this was a final decision of Justice Glasgow, that does not offend the Constitution at all. What the Constitution does require explicitly is that we have fair hearings and that we have a fair process, a fair elections process. And that is what we fear has been offended by the decision of the learned Justice Glasgow and by the Court of Appeal. Just to give a brief background, I'm not going to take too long on this, but I understand that there were a lot of petitions and a lot of documents. So I just want to be sure that we're all clear on the background facts. So the applicants, who were then the petitioners, brought 10 election petitions in the High Court in Dominica. They were for essentially the same complaints, and in each petition, and there were varied complaints depending on the particular constituency. We were obligated to bring our petitions the way that we did by virtue of the House of Assembly election petitions rules, which specify exactly how you have to file election petitions. So everything we did was in compliance with those rules. And that is important on the issue of costs, which we will discuss later and or in our submissions. But it's important that we understand that we came within the ambit of what the rules asked us to do. In our petitions, we made several complaints, all of which we said individually and or collectively meant that we did not have a fair elections process. The rules or the laws on the fair elections are very explicit, and they say if the elections are not conducted in accordance with rules, or there are several irregularities, that the court has to consider that the elections are null and void and should be vitiated. And it goes as far as to say, and I will take the court to that section later on, that if the irregularities are so vast or so extreme or so numerous, there is no requirement that the court has to determine that it affected the results. As long as there are numerous or too many irregularities in the process, then that vitiates the result. And what we pleaded were several important irregularities where rules were not followed. And these are just our pleadings, I'm not justifying them. The wrong lists were used, the objections process wasn't followed. The national radio did not carry our elections. our campaign. And all of these matters, whether we're looking at statutes, whether rules or the common law, all of the matters that we plead by themselves or individually would shape the result if true. That's what we brought before Justice Glasgow in great detail. And I will take the court, Your Honor, into the sections of the petitions of the, Justice Glasgow's decision, where he acknowledges that he got great detail. And yet our petitions were dismissed for failing to have sufficient particulars. Now, Your Honors, a strikeout application was brought by the respondents. And they asked for it to be struck out because they said we brought the wrong parties, people were sued in the wrong names, and so on. Justice Glasgow did not agree with that. He thought we were on time, or we were in time to bring our petitions, and the right parties were before the court. Now, these, in my mind, and based on the law, are clear procedural issues, clear interlocutory issues. Whether you're on time or not, whether you have the right parties or not, that has to be established before you can go any further. The judge agreed with us, the learned judge agreed, you have the right parties. Then they asked the court to determine that we abused the court's process by bringing petitions. Abuse the process generally, and in my petitions, we detail all the case law and what that is. And in Justice Glasgow's decision, he set it out quite clearly what abuse of the process is. But essentially, that the pleadings that are so ridiculous that it's not worth going to court. It doesn't make any sense. Or maybe it's something that was already decided. That's the abuse of the process. The learned judge Glasgow decided no abuse of process. Absolutely nothing is an abuse of the process. Then the final complaint that they had, which they were successful on, was to say we did not have a cause of action in our petitions. Justice Glasgow, in his decision, it's a repeated comment that there's not enough particulars, the pleadings are insufficient. I think that's the term he used over and over. Pleadings are insufficient. Now, I think what happened, if my memory is correct, I think the Court of Appeal their position was, look, the court has a discretion. Judge has a discretion as to when he decides if something is insufficient or not. But Your Honors, our argument is that that insufficiency conclusion has to be grounded in what all of the case law have said, which is that the defendants do not know what they are being asked to defend. That's when the pleadings are insufficient. Your Honors, not only did the defendants never say, the respondents, they never once said that they had no clue what they were being asked to defend. In fact, what they did instead is to say, here's our defense. And Your Honor,
Miss James, if I could stop you a little bit.
Your Honor.
You say that the pleadings were sufficient. Suppose the pleadings were insufficient, which you say is not the case, but suppose the pleadings were insufficient and the judge had rightly struck out the case on that basis. Would his decision then be a decision that was appealable or not?
Well, there's a couple of ways of looking at this. Now, I just want to be clear, Your Honor. My argument is not necessarily to say the pleadings were sufficient or insufficient. My argument is that Justice Glasgow found the pleadings insufficient on the merits of the claim.
I don't understand. I don't understand.
I'm coming to that.
I asked you a question. You avoided answering my question.
Yeah, no, Your Honor, no. I'm sorry. Justice Glasgow, if the pleadings are struck out for being insufficient because we have no idea what you're being asked to defend, that, Your Honor, is a different matter where you can say, well, all right, well, the pleadings are clearly insufficient. They don't know what they're being asked to defend, and it's struck out on that basis. The reason I hesitate in how I answer it is that
an appeal from that decision.
if it depends, Your Honor, I just want to be very clear that there's two ways of looking at it. There's a case from Kenya that we relied on that said once the pleadings are struck out in their entirety, the common sense approach is that it's appealable and it's final. And we've asked the court to adopt that position. However, even if the court does not want to go that far, and the court should also examine that the reason for it being struck out. So if it's struck out on the substantive merits of the case, then it is appealable because it's final. Mm-hmm. If it's struck out, and that is the case law, that is the case law in the Court of Appeal that we rely on. If it is struck out because the defendants don't know what they're asked to defend, it's for example, we're on an election petition and we're claiming somebody robbed us. It's struck out for not knowing what you're asked to defend because it has nothing to do with election petitions. And it's struck out for that reason. We understand that that is a good reason to strike out a claim. But overall, Your Honors, our position is that once you strike out petitions in their entirety, and in particular on its merits, not because you don't know what you're asked to defend, but because the judge is looking for evidence and dealing with it as if there is and making substantial findings of evidence and fact on the substantive claim, then that is a final decision and that is appealable. I hope I've answered your question, Your Honor.
Well, I'm still a little confused, but you're saying here that the judge made findings of fact?
The judge in his decision made findings of evidence and fact that went to the substantive case. And how I can clarify this better, I think is to refer, my lord, to what the law is, starting with the Supreme Court Civil Procedure Rules, Part 2000 Civil Procedure Rules, which speak to what is an interlocutory and what is a final matter. I will get the section of the rules. It's in my submissions. So it's part 62.13b of the Civil Procedure Rules. Now, in my submissions, my substantive submissions, the last set that I filed, at paragraph 25, I do lay out the section. And we did not upload the CPR, but it is 62.13b of the CPR. And if Your Honors are ready, that section says, an order or a judgment is final if it would be determinative of the issues that arise on the claim, whichever way the application could have been decided. It's very simple. If you determine the substantive issues.
Okay, let me ask you another question. These petitions are to be filed within a certain period of time. Is that correct?
Yes, yes, Your Honor.
What is that period of time?
21 days, Your Honors.
21 days, okay. Suppose you and the court office and the judge were super efficient, and these the judge did what he did here on day 15. Would it have been possible for you to refile the case with the gaps which the judge identified closed on day 16?
I'm not sure I understand the question, Your Honors. Sorry.
Okay.
No, I don't think I understand the question.
Okay, let us assume that the judge on day 15 of 21 days.
Yes, Your Honors.
Did what he did here. Struck out the case because he said you didn't plead that, there was no particulars about that, and so on. On the 16 or 17 or 18, you refiled the case, closing all the gaps that the judge identified in this judgment.
Yes, Your Honors.
Wouldn't the judge be able to hear that refiled application?
Okay, so let me see if I understand the question. The question is, if we filed within the 21 days, and within that time, the judge was able to look at the petitions and suggest that certain things were absent or we needed to file better particulars. Well, then, if I believe that's a matter within the judge's discretion. Counsel for the respondents argued quite a bit that there is no room to to amend after 21 days. There was no discussion about amending within the 21 days. But I suppose there's nothing that prevents that if that's what the court would want to order, and if that's the position of the court, that we have that 21 days to perfect our petitions effectively. So yes, I would think that we could refile within that time.
I would think so too. And so what I'm driving at is that the decision would not be final, because if it were final, then the only recourse would be to appeal. In other words, if there were no time limit, if you didn't have 3 weeks, if there was simply no time limit, after Justice Glasgow gave this judgment, in lieu of appealing, you could have simply refiled.
Okay, yes, Lord. I follow you, Your Honor.
Okay. And therefore, isn't that an indicator that his decision was not a final decision?
No, my lords, Your Honor, I don't believe that, and I respectfully disagree, because the first issue is that that's not what happened. We were heard, must be 3 or 4 months after we filed the petition.
I know.
Right.
So that it is the time limitation.
Yes,
that
but
you are using to render the decision a final one. But
no,
absent the time limitation, you were perfectly able to refile the case because the decision was not final.
Oh, right. Your Honor, the election petitions are, as you would hear counsel say, are a unique, very unique area of law. That's the first thing. And so I'm not sure that we would have had the same ambit as a regular case. But very importantly, I don't believe that if a judge says, you have not given me the evidence to support your case, and I will go into the examples of that. You have not given me any evidence to support that these elections, that what you say affected the results, especially when the things that Justice Glasgow was asking for are things that we would never have filed because it wasn't our case. And we will get to that. Then that is final, and the only way to go is to appeal. Because even if we amended the case, the result will be the same, and that is why it's final. So for example, on the question of the misuse of the national radio, we argued extensively that the opposition parties were not covered at all by the national radio. We showed case law all the way up to the Court of Appeal. And that said, if the national radio is misused in that way, that vitiates the result of the election. End of story. What the decision of Justice Glasgow said is that we needed to prove to him that the Prime Minister of Dominica or agents of the Dominica Labour Party told DBS what to do. And because we did not prove that or plead that, then that was it for us. And he struck us out of the ground.
There's a difference between proof and plead.
Right.
He can't properly say that you didn't prove it because you had no opportunity to lead evidence, to go in the witness box and give your evidence. But certainly there's a requirement to plead sufficient facts that would put the other side on notice. And as I understand it, that is the ground on which he thought that the case was insufficiently pleaded.
Your Honor, we would never have pleaded that Roosevelt Skerrit and agents for the Dominica Labour Party gave instructions to DBS, because that is not our case. We have no way of knowing that, no matter where we went, whether we went to trial or not. What Justice Glasgow did was to rely on a particular case of the Court of Appeal called Mark Brantley and Parry, I believe. I don't have I will find the exact quotation. But that is a matter that went to trial. And he relied on the evidence that came out of that trial and determined that we must have the exact same facts and evidence. And if you read his decision, that is what he's done. So it has to be a final decision. It's not insufficient for not knowing what the other side is asked to defend. It's insufficient because he did not think the facts and the evidence would please him and make him believe that we could win this case. So that was a final determination of the substantive issues. So we are not talking about, you've not filed in time, you brought the wrong parties, so go ahead and amend. We are talking about a judge that for all intents and purposes, even if we went to trial, made a final determination on the evidence. And that is why I started off earlier by saying that the question of insufficient facts is grounded in, do you know what you're asked to defend? Justice Glasgow, in every head of complaints, he recognized the cause of action. He spelled out what they were being asked to defend. And then he said, well, that doesn't satisfy me because I want these exact facts. I want this exact type of evidence. And you have to show that to me now. And if you don't show it to me now, you're struck out. So in other words, had we gone to trial, it was a substantive finding. Justice Glasgow, the learned judge, made a determination that the candidates that we petitioned against were validly elected. And Your Honors, my position, our position is entirely supported by the law.
Ms. James, I
Yes.
got the impression that the learned judge was looking at the standards that had to be met for the overturn of an election.
Yes.
And he was looking to see whether the case as pleaded could have had that effect of overturning the election. Mm-hmm. Is there anything inherently wrong with that approach? In other words, I think he was trying to see whether the case as pleaded was viable from the point of view of the overturn of the elections. In your view, is there anything impermissible with that approach?
Your Honor, that is entirely the right approach. That is the right approach. But what we are arguing against, and what we said in our written submissions, is that the Justice Glasgow set out the law that we are supposed to comply with. He set out where the causes of action are. He sets out where we plead the correct causes of action, and then he dismisses it for want of evidence, for want of further evidence. So, for example, on the question of the revised list,
I'm sorry to interrupt, Counsel, but was it for want of evidence or want of specificity and particularity?
Okay, so thank you, Your Honor. So the question is, how much specificity, how much particularity, I'm sorry, I have some orthodontic treatment, so there's certain words I'm going to struggle with, I apologize. How much particularity does a judge ask for in fairness? If the law is that the national radio must be used in a matter, it must not be misused, and we've pleaded all the instances where they've misused it, we've pleaded that it's a state radio, it's a national radio, that is our cause of action. When a judge asks for further particulars, that we have to say that that is not enough. You need to tell me that agents of Dominica Labour Party specifically told the radio to do this. Never mind that the radio belongs, is owned and run by the government. But besides that, why are we asking for that type of evidence? And if we're asking for that type of evidence or those types of pleadings, and you dismiss us for want of it, then you've made substantive findings. So there's nothing wrong in making sure that we've pleaded something that's known to law. That's fine, and that's what we did, and that's what the judgment recognizes that we did. For example, Your Honor, another example, on the question of the revised list, there's a section about the revised list. And what we say is that the revised list by law was mandatory. It had to be used for us to have a fair election. And if you go into the various laws, and there's several election statutes, it says why the revised list is important, because it has to be compiled with a very specific process contained in several statutes. What that case from St. Kitts, that Mark Brantley and Parry case said, I'm going to get the exact case, the name of the case, because it's important.
Was there a revised list? Is your pleaded case right that there was no revised list?
The pleaded case in the specific piece, pleaded case, Your Honors, and I intended to take you to the pleadings, But essentially it was that the revised list was mandated by law to be used. It was not used, and that made the election null and void. Now, this case I was looking for, Joseph Parry and Mark Brantley, which, by the way, we fashioned our pleadings almost exactly like this case because there were so many similarities. But what that case said is once that revised list is not used, that's it. Your election is null and void. Clear as day. You don't use the revised list, the election is null and void. The judgment of Justice Glasgow said, and it's incredible because I really think it's worth reading it and taking the court through it. And I can do that if the court would like me to, but it's in my submissions and it's in my notice of appeal that was filed at the Court of Appeal. But what the judgment said is that I recognize absolutely the revised list had to be used. I recognize that the revised list was not used. The defendants have not said the revised list was used. And I don't see anywhere where they said it was used. So that's our cause of action right there. But then the judgment goes on. And the judgment says, but they need to plead and satisfy me that the list that was used was not a good list or that it affected the results of the elections. He needed to see the list that was used and to compare that with the revised list, which, by the way, was never published. So we are now to find a revised list that was never compiled, never used, and compare it to the list that was used and put that in our pleadings to say this is the difference in the list. And then the judgment just ignores the fact that this Court of Appeal decision is before him. That says,
yes, can you give us a paragraph in the judgment that speak to that?
Absolutely.
Just the paragraphs.
Paragraph 141. I'm going from my memory. So, sorry, 129 to 1. Let me not go from my memory. Let me find it. I think it's 129 to 131. Let me just get the decision. And I can read it to you, my lords.
No, I don't want you to read it.
Right, 129 to 131. This is a final finding, a substantive finding on the use of the revised list. He's identified the cause of action. He's identified what they're asked to defend. Completely ignores established Court of Appeal laws and asks for more and more and more information that, frankly, we cannot be done. We don't have a revised list. It was never used. Dominicans went to an election in 2019, Your Honors, without a revised list. And that is crucial because that is how we know that we have a proper list of electors, that they are validly entitled to vote. The most important thing on an election day. And we were dismissed for insufficient pleadings. That is a substantive finding, Your Honors. And that is essentially the entire judgment. Every single, we filed our notice of appeal that was filed at the Court of Appeal. It lists, I almost thought it was prolix because we list in detail where this is what happened. Identify the cause of action, identify what you're asked to defend, but once more pleadings. And Your Honors, the case, the law is very clear that a matter can start off, can be initiated on a trial court application, which we generally think of as interlocutory, which is fine. But the case law is clear that an interlocutory matter can change when it goes into substantive areas of law and where a judge makes substantive findings, and then it's final. So at the Court of Appeal, all parties relied on a case called Nevis Island Administration, which is, I don't know if the court needs me to take them to the case, but in my submissions, I do set out what that case says. Interestingly enough, that case was not referred to at all in the Court of Appeal decision, but it's a Court of Appeal decision referred to by both parties. There was no mention of that case, and in our opinion, that case settles the matter as to how we determine whether a matter is final or interlocutory. And in my submissions, my last submissions that were filed on December 23rd, at paragraph 37, and those submissions are found at 1637 of the CCJ bundle. And what I'm about to read is a—
Sorry, what page?
It's okay. So it is in the bundle. Those submissions can be found at 1637 of the court's index. And I am on page 1644, paragraph 15.
Paragraph 15, you said?
1644.
No, paragraph what? What
paragraph? 37. Apologies, paragraph 37.
Your submissions.
Of my submissions, yes. And so what I do is that I've extracted the section of the case I want to refer to because I thought it was so crucial. And because this is a settled principle. It's not up for, it's consistent. It's very consistent. And what I refer to that case, Nevis Island Administration. What that case says at paragraph 15 to 16 is that the application tests, and I'm sorry, I want to be very clear that everything I'm saying, all of the submissions, we accept that we're using the application test, okay, not the order test. But this is not a question for us. This is what the application test says. And it's consistent with the CPR that I just spoke about earlier. The application test accepts that a claim could be totally and effectively disposed of on an interlocutory application without there being a determination of any of the issues which arise on that claim. Okay, the issues are revised list, access to the radio, or substantive issues. The case could thus be disposed of, and yet the order is not a final order because none of the issues on the claim has been determined. So the question is, have all issues been determined? Under the application test, the resulting order is an interlocutory order, okay, because none of the substantive issues have been determined. An appeal from such a decision is also a procedural appeal within the definition of the term in 62.12 of the CPR, because it is a decision which does not directly decide the substantive issues in a claim. Under the order test, on the other hand, the decision is final if it is made on a substantive determination of the issues that arise in the claim. However, quite contrary to what obtains on an interlocutory decision, the order will also be final if it were made on an interlocutory application. If it totally and effectively disposes of the case and decides the rights of the parties without a determination of the substantive issues that arise on the claim. So, Your Honor,
just a minute, Ms. James, pause. Didn't that sentence say the order will be final?
There was an order, Your Honor.
No, what you just read. First, that last sentence. What are the first few words?
The last sentence?
That you just read.
However, quite the contrary to what obtains on an interlocutory decision, the order will also be final if it were made on an interlocutory application, if it totally and effectively disposes of a case and decides the rights of the parties. Okay, so and that is consistent. Now, there's a case the Court of Appeal relied on called, let me just be sure. I think that was the main case. Excuse me, I'm just finding the case. Hamilton versus Liburd. Court of Appeal refers to that case extensively. And that case is found at 2835 of the bundle, Your Honors. Can I have it, please? 2835 of the bundle. Okay, I think I have the case. I have the case. And at paragraph 18 of that case, Your Honors, I have the case management. Paragraph 18 of that case.
At what page?
Okay, I do need it then. Najma, I'll tell you where it is. 2835. I'm sorry, my lords. I will find it. Okay, I have it here. It is Hamilton and Liburd 2835. That's where it is in the index. I'm at paragraph 18. Paragraph 18 is what page?
2872.
Sorry?
2872, is it?
Oh, we found it. Okay, it's in a couple of places. So 2872. But I'm at paragraph 18 of that matter. Now, we just have to bear in mind that the Court of Appeal relied on this decision. And in this decision, all the parties accepted that they were there on an interlocutory application. So that was not in dispute. What was in dispute is how you treat an interlocutory application. We are disputing that our matter is interlocutory. But at paragraph 18, you see that case sets out the exact same criteria as the Nevis Island Administration case that I referred to. So at paragraph 18, the last sentence that starts the decision. Right, and sorry, the last sentence says, such a question does not arise in these cases, and it is common ground and indeed indisputable that there has been no final determination of this matter. Sorry, let me get the full, hold on. Right, yes, sorry, it's a sentence that starts with the decision. The decision, so this is the court referring to an earlier precedent. And it says, the decision to the effect only that the Section 36 of the Elections Offences Ordinance of Malaysia applies to all cases where there has been a final determination of the matter, whether it be on procedural grounds or upon the merits. Such a question does not arise in these cases, as it is common ground and indeed indisputable that there has not been a final determination of the matter. So the court said there's no final determination of the substantive matter. And in paragraph 20, it goes on. In paragraph 20, it continues to support the issue that whichever way the test is applied, it's an interlocutory order because it does not deal with the substantive issues of the case. Once you determine the substantive issues of the case, then that is a final decision. Now, we've relied on another case. It is, let me not confuse myself, Your Honor. I'm trying to make from memory, and I will go to
Ms. James, Ms. James, before you go on to your next case,
yes,
wanted to ask a question for a while. Having regard to what you said to us this morning, and you said in your written submissions as well, it appears to me that what you're saying is that the judge got certain things right. He may have had certain things right, which is that he may have looked at the pleaded case and said, okay, you have insufficient particulars, you have insufficient pleadings, I'm not satisfied. That is how I gather that you're saying. You're saying, but the judge did not stop here.
Mm-hmm.
If he had stopped there, you probably would not be here.
Correct.
Yes, Your Honor. Yeah, so you're saying the judge now went further. Yes. And ask for evidence and ask for things that if you are right, you're saying he should not have asked for those things. How does that impact your argument before us? Did the judge get right what he was supposed to do, which is that he got right that there were insufficient pleadings? You could live with that if that were the case. But you say now he goes on further. How does that impact your argument? That is the little struggle that I'm having.
Okay.
Does it change the nature of the application before the judge if he went too far?
Yes,
Your Honor, he could not. He was not sitting and hearing the petition Correct. On that day.
Yes, Your Honor. He usurped the position of the trial judge. These questions and these things he was asking for is for trial. And it's problematic because the House of Assembly petition rules explicitly told the petitioners not to plead evidence. That's number one. And number two, the judge relied on final decisions in election matters, which had their own specific facts. And he insisted that they had to apply to our case. So in the case, the Parry case in St. Kitts, it had their specific facts where they were able to prove what the premier did. Our case wasn't that. But what we had in common was that there was a misuse of the radio. And further to that, and Your Honor, just to be very clear, so I'm clear with you as to what you're asking. There's a case that addresses this completely. Well, I think all the other cases I've spoken to address it, but there's a case called Nevis Island Administration, which is at...
Is that the case you just took us through?
Oh, sorry. Consolidated Contractors. I had everything perfectly before me, and all of a sudden, nothing is before me. I apologize. Consolidated Contractors, which is found at number 1672 in the CCJ bundle. And the court is asked to apply a broad common sense test as to whether something is final or interlocutory. And it actually says once you touch substantially on what should be substantive issues, just as Your Honor just said, things that really should be left on for trial, once you touch on that, you have to consider that you've made a substantial finding and that the decision is final. But Your Honors, that's not the only issue that we have with this decision. That's not the only issue that we've had for this decision. Is that the judgment, and you will see in our various different applications and documents, that the judgment misstated facts that were pleaded. And this is where we get into the public importance realm more than ever. We were already there, but more than ever.
Sorry,
example, yes.
To interrupt you, Ms. James, about the point you're going to make. But just before you move on to that, could I just delay you 1 minute longer on the application test that you were just describing for us?
I'm sorry?
Could I just delay you a little bit to ask a question?
Yes, Your Honor, yes.
On the application test before you move on? There is another case, I believe, from the OACS, McDonough against Richardson, decided in 2005, which also speaks to the range of the application test. And I gather that the statement here by the judge was that, to the effect, it did not matter if the effect of the order was to bring an end to the proceedings. Even if it brought an end to the proceedings, it could very well be that the order was an interlocutory order and not a final order, given the application test. I just wondered if you were familiar with that and wanted to make a comment on it before you move on.
Absolutely, Your Honors, very familiar with it, and that's what my friends are going to put before you, that type of argument. That is not, our position is that is not representative of what the full scope of the application test is. So, for example, we understand, like I've said earlier, that having a matter dismissed because you've not brought the right parties, or because the proceedings were not followed in terms of how you file a writ, and the matter is thrown out on that basis, of course your matter is done, but none of the substantive issues were touched. And I would not be surprised if that was the case in the case Your Honor has referred me to. I'm not familiar with it, but every single case relied on by the respondents and relied on by the Court of Appeal were matters that were clearly interlocutory, where the matter was completely thrown out because the wrong writ was used, the wrong parties were used, the person did not have, the applicants did not have the right locus standi, and so on. That's different. If a matter is dismissed for those reasons, it does not touch the substantive merits of the case. Nobody is unfair because we didn't meet the rules, the basic guidelines. Do a certain thing, there's a certain process you're supposed to follow. And if you're struck out, then your whole case is struck out. But that's not what happened with us. And the case law is very clear that on the application test, Your Honors, when you have an opportunity to review the cases that we've relied on, or even that the Court of Appeal relied on, or the respondents relied on, this is literally the only case before the court where persons were struck out on the merits of the case, of the substantive case.
Okay, thank you.
Thank you, Your Honors. But Your Honor, to further answer your question, because we do rely on a Kenyan case that was one of the last things we uploaded. which does say that a common sense approach is that once you've struck out an entire election petition, then that's a final decision. And that's something we ask the courts to consider. I will let the court know exactly where that matter is. But that's another issue, and I think either way, we're fine. We're within the law. But that case is at. Why have I lost it? Forgive me, Your Honor, just one moment. Yes, and that case was filed in my reply. My reply is at it was filed in my reply, and I refer to it in my reply. My reply is at 2972, and the case is 2978. And in that case,
what is the status? What's the level of that decision in the Kenyan system?
That is a Kenyan case. It's at the Court of Appeal.
Court of Appeal, okay.
And it finds at paragraph 10. It says, however, in our view, if an appeal is against a decision of the High Court allowing an interlocutory application seeking striking out of a petition, then this court would have jurisdiction to hear it. For an order striking out a petition is a final decision on the petition, and an appeal from it is no longer interlocutory, but is an appeal on a final decision on an election petition. This, in our view, is only where an application for striking out the petition is allowed and the petition is ordered struck out. Okay, and so in that case, they had the same situation, final or interlocutory, whether or not interlocutory decisions can go beyond a certain court and so on. The facts are on all fours like ours. And they made a determination that, look, once you strike out a petition, it's final. But Your Honor, Justice Anderson, I do appreciate that based on the rulings in the Caribbean, we do have the order test and the application test. But on the application test, the result is the same as that Kenyan case, because you've gone into the substantive findings. And this is really relevant because all of the case law says very clearly that if you just have a teeny tiny bit of a cause of action, I think the language is even the most scantily pled claim should be allowed to go to trial. We have a position where we're pleading everything on the kitchen sink. And then the judge says, oh, no, that's wrong. But the point I need more. I'm going to ignore established Court of Appeal precedents and just ask for facts that aren't relevant.
Ms. James, I thought you were through with your point. Whenever you get a chance, have a look at paragraph 20. I know you know it well, of the Court of Appeal decision, and just let us know what you think of that. Yes. Because that is the same point that you raised before the Court of Appeal in this matter. And the Honorable Chief Justice, who wrote the opinion, says, look, this is an interesting jurisprudential question. And it doesn't appear to be addressed by the Court of Appeal before. And that is the same question, whether decision, which would ordinarily not be a final decision, can lose its character. So it's yes. Just what you're telling us now. Yes. But the Honorable Chief Justice didn't feel that that is so. She says, I am not of the view that the learned judge determined the matters before him in such a way that could transform his decision into a final decision within the meaning of sections 46 and 47 of the Constitution. And I think she says the same thing again at paragraph 26. In my view, she said, last sentence, the judge did not step outside the permissible bounds of the court on an application to strike. So that's fairly strong language on her part.
Yes.
Are you satisfied that in your written submissions of what you've told us so far, you have been able to say to us that the Chief Justice was wrong here?
Yes, Your Honor, there are a couple of things I would like to say to that, and I do address it in my submissions. Number one is, this is not a novel, that was not a novel argument that I put before the court, given that we relied on Court of Appeal cases. So the court was familiar with that argument. That's the first one. Number two, the court, later on in that decision, the court actually says, we are not going to go through Justice Glasgow's decision to satisfy Ms. James on this issue or to satisfy the petitioners. We don't need to do that. We don't need to go and look at every point in that decision to make that determination. And what is important in that, what is important in that decision is that the judge says, look, the justices of the Court of Appeal said, Justice Glasgow set out what his mandate was. He understands his remit. He went into a long discussion. I'm not supposed to go into evidence. I'm supposed to take the pleadings as true, and so on. And they said, we believe him. He said he was going to do it, and he's done it. So we're not going to look any further. And so, Your Honors, the fact that, and that is exactly what the Court of Appeal did. They believed the judge without going through his decision. And we took the justices through the revised list question that I just spoke about. And if I were allowed to go through that paragraph, or when Your Honors get a chance to go through that paragraph, I don't think there's any way we could come to the conclusion that this judgment didn't ask for evidence. The Court of Appeal does not mention that. The fact that the judgment disregarded judgments from the Court of Appeal in Joseph Parry and Mark Brantley, not mentioned at all. So we are not convinced that the Court of Appeal took any time whatsoever to see if the judge really did or did not go beyond his mandate or make substantive findings. And they said they weren't going to do that. So what the decision does, it picks out, cherry picks one or two paragraphs and says, oh, we're satisfied. And that is exactly what the respondents have done, because they do refer to certain paragraphs, cherry pick certain paragraphs and say, oh. And that is why it's really important that I would like the court, please, to look at this paragraphs that we've identified. If I can't do it on my feet this morning, I would before I leave with my submissions, I would like to point the court to the paragraphs in my notice of appeal where we go into detail. Now, the other issue that we spoke about is that the judgment misstates the law or misstates what was pleaded. So, for example, something very important.
Which judgment? The Court of Appeal judgment or
Justice Glasgow's decision. So, for example, we make a complaint that section, I think 32 or 30, let me get the exact section, I'm sorry. Oh, wait. Right, we made a complaint in our petitions that section 34.3 of the regulations of the Registration Electors Act was not complied with. That has to do with how the public can object to names on a list, and the fact that you are obliged to show the chief elections officer is obliged to show the electors and the public who are the persons newly appointed to the list. It's very important to the elections process. And what the persons in charge did was to hide that list. They did not reveal. I mean, that's our allegation. They did not reveal the names of the electors for people to object to. That's incredible. So we said that violated section 34.3 of the Act. The judgment says, makes no reference to section 34.3 and says we pleaded section 32. Section 32 has nothing to do with the issue. And of course, we're struck out. Now, I understand that the judge has a discretion, but what do we do when a discretion is so blatantly misused? Where do we go on an election petition? And there are several instances of this. What do we do? Where do we go? On an allegation that voters were imported, that thousands of electors were transported into Dominica, paid for by the Labour Party. We said hundreds of thousands of electors were brought into, paid for and brought in to vote. No, sorry, we said thousands of electors were brought in, and it cost hundreds of thousands of dollars. My lords, I deliberately made the point of uploading the respondents' response to that back in the High Court. They admit it. The document is 2994 of the High Court of the bundle. And at paragraph 9.273 of that document, they say the petitioners admit that the Dominica Labour Party and its agent provided transportation and its supporters. And they go on to refer to the exact section that we complained about, where we talk about thousands of people being brought in. And they admit it. They admit it where I've just read and in other parts of the document. They did it like a defense. So they refer to the allegation and say we admit it. But we brought in our supporters, so that's fine. They're not saying they don't know what they're asked to defend. How is this? Not only is importing voters and paying thousands of dollars, hundreds of thousands of dollars, and bringing in thousands of people to vote, an elections offense under section 56 and 57 of the House of Assembly Act. That's in my documents, Your Honors. But that's a cause of action in itself. And we also say they corruptly did it. And they said, yeah, we admit it. This judgment decides, well, there's not sufficient pleadings because I don't know who the people are that came in. It's been admitted. And I just want to be very clear that there's a lot of discussion within the decision that the judge was not satisfied, Justice Glasgow, that we showed how the election result was affected. And within the judgment itself, the judge correctly identifies the law. So I'd like to take the court to the decision of Justice Glasgow. I'm having very bad luck at organizing my documents. The decision of Justice Glasgow, paragraph 81, that decision can be found at 43 of the bundle. And the court correctly refers to a case called Morgan versus Simpson, which the judge correctly identifies it as one of the leading decisions on election petitions. And the first section of that decision, paragraph 81, the first section of Morgan and Simpson says, if the election was conducted so badly that it was not substantially in accordance with the law as to elections, the election is vitiated, irrespective of whether the result was affected or not. That's one of the main limbs. So we don't have to show even at trial how the result was affected. But we have a decision from Justice Glasgow on a strikeout application. You've not shown me how it was affected. Separate to that is the fact that how it's affected is for trial. We were ambushed. We could not have one. This has to be a final decision. The Lords, Your Honor.
Miss James, in a sense, could I take you back to where we started? I know you have several difficulties with the decision of a learned judge, obviously, and you have spelled out, I'm sure, many of them this morning. But could I ask you, are you saying to us that the decision of the judge, Justice Glasgow, was a final decision on the question of the validity of the elections, which took place in 2019? Absolutely,
Your Honors. Justice Glasgow determined that all of these individuals were validly elected because he made final findings. There's no other way it could have gone. And he touched on
to strike out the pleadings as not indicating sufficient particularity is tantamount or the same thing to deciding that they were validly elected?
Okay, Your Honor, it's really a matter of us accepting what happened in that decision. We have a judgment that says, I've struck you out because you've not pleaded sufficient particulars. On any other day, we say, okay, fine. But that is grounded in a thing. It's not just for a judgment. A judge does not have the discretion to just say, you don't have enough particulars. And I really believe that that's where the Court of Appeal might have gone wrong here, in that it allowed itself to believe that because the judgment says, I don't have particulars, well, that's his mandate at the end. But that is grounded in a thing. And the thing is, have they pleaded enough information that the other side knows what they're asked to defend? And he's accepted that, my lords, he's accepted that. And I really think it's important that I read this section to you of the decision so that I can make it crystal clear. And then that can be an indication for everything else to make that crystal clear, because I don't want us to get I don't want us to allow ourselves to be misdirected by when the judge says, I don't have sufficient particulars, and think that that was his duty. He has to explain why. And his explanation takes us into the substantive merits of the case, and everybody was validly elected. And that's where we are. So if I could just take the court to paragraph 129 of the substantive of the judgment of Justice Glasgow. And I'm going to read until 131. And I think this is going to make it crystal clear. If it doesn't, then I don't know how else will. But I think as long as we accept that the judge is not supposed to go into the substantive merits of the case, I think this is going to explain why we're here. Okay. It says, paragraph 129 starts. I don't know if we all have the page of the Glasgow decision. Paragraph 129 says, the respondents, and but in that case, we're talking about our respondents, are right and about most of their submissions. My only point of departure is my view that the electoral officials were enjoined to follow the law. Okay? Enjoined, the elections officials had to follow the law. We said they didn't. Section 17 of the Registration Act states that the revised annual lists and the supplementary registrar shall constitute the register of electors for the respective polling districts and shall be used as the register for any election. If the pleadings are taken as correct, we know they have to take it as correct, then the use of the preliminary and supplementary registers at the 6 December 2019 elections was a patent non-compliance with Section 17 of the Act. That's our cause of action. This is where we're supposed to end. But no, he goes on. There may be valid reasons for the non-compliance, and the respondents have been at pains to take the court into the weeds on the issue, which means the respondents have not satisfied him that they complied with something that was essential. The parties engaged in an illuminating and spirited discourse on the approach the court ought to take with regard to whether or not electoral officials acted properly. So this is where the judge is being taken down the road of evidence. So this is them. They cannot say they didn't know what they were asked to defend. I am not unduly troubled by that disputation unless the respondents can show me that the pleadings should be removed as a blatant abuse of the court's process. I don't think they're abusive. Rather, I think they're inadequate. Inadequate? What is it? He goes on. The true concern in my view, and frankly, the difficulty that confronts the pleadings, is a manifest lack of any reference to whether this purported breach of Section 17 of the Act had any impact on the elections, and if so, in what manner did it impact the results? That's for trial. An impact on the results. The judge had already quoted Morgan and Simpson that said, we don't care how it affects the results if the irregularity is so vast.
No, but stop there. Morgan and Simpson said that it has to be so bad that it can be regarded as substantially vitiating the elections.
That's right.
If you merely demonstrate on the pleadings in non-compliance, but there is nothing on the pleadings to suggest that that non-compliance by itself is so bad that it renders the elections vitiated, then can it not be said that the pleadings by themselves do not support the cause of action?
My lord, the pleadings do say that, and I will take the court to the pleadings.
But is that what the judge is saying here? that yes, you have pleaded a non-compliance. I'm satisfied that you have pleaded a non-compliance, but I am not seeing anything on the pleadings that suggests to me that that non-compliance fell within the first limb of Morgan and Simpson.
My Lord, the judgment says at paragraph 129, it's a patent non-compliance and they were enjoined to follow the law.
Yes, everybody accepts that. And my question to you is whether it is that a mere non-compliance with the law is sufficient to fall within the first limb of Morgan and Simpson, as you suggest.
Well, my Lord, it falls within every limb of Morgan and Simpson, and it falls within the limb of the Brantley case, which is that once you don't use the revised list, the election is vitiated. Non-compliance with the laws is something for trial, and we pleaded non-compliance with the laws, and the judge accepted that that was a patent non-compliance, and that was important. And he goes on to say, and my Lord, he says why. He actually says what it is that he's looking for, if I can be allowed to continue. This is what he says. Questions that arise and should have been addressed on the pleadings are whether, so he goes specifically into what he wants, whether the breach amounted to an elections offense or irregularity. He just said it's an irregularity and offense. He just said that in the last paragraph. And if so, whether and how it affected the results at the polls. Morgan and Simpson says you may not necessarily need to do that. How it affected the results is not necessarily the case if it's a patent non-compliance. How extreme the non-compliance is for trial. He can make that determination, but at trial. If the alleged breach did not amount to an elections offense or irregularity, but we know it did from his own discussion, the question which arises is whether or not it was such a substantial departure from the norms or dictates of the electoral laws sufficient for the court to set aside the election as being one that was not an election at all, or what transpired was a travesty or a sham. That is for trial. He's asking for evidence. Paragraph 131, even more egregious. In my view, for instance, if there was no material difference between the registers required by Section 17 of the Registration Act and the registrar actually used on the elections day, what would be the point of setting aside the exercise of the voters' franchise? In such cases, it remains for the petitioners to demonstrate on the pleadings the difference between the registers and the impact of the results sufficient from a credible basis for setting aside the elections. In short, the mere pleading of a breach of electoral laws by elections officials without more is inadequate. But he had more. He said what the more was. The paragraph in support of these allegations on all the petitions are to be struck out. Now, my lords, if I could just take you to what exactly we said. This is what we said exactly. I've uploaded the Roseau Central petition. It is at number 230 of the CCJ bundle. What we say at paragraph 21 and 22. On the 26th of November 2019, the Electoral Office published a press statement indicating that the Electoral Office of Dominica informs the public that as required by law, the preliminary and supplementary registers have been issued and will constitute the final lists for the December 6, 2019 elections. No, they don't mention the revised lists. Okay? The polling clerks and the returning officers were mandated by law to use the revised annual list and the supplementary list on polling day. By failing to use the revised annual list as the register of electors, the polling clerks, the returning officer, and the chief elections officer acted unlawfully and thus rendering the elections null and void. If we're asking for more information, we're asking for too much, and it's not fair, especially when we consider the case of Mark Brantley and Parry. And I would take the court to the exact section of that case that we relied on. Yes, Your Honor.
Before we enter in more details, can we just for a while go back to the idea that something must be a final decision, because
yes,
the whole jurisdiction turns around that.
Yes, Your Honor.
So I think some nuances could be made. For example, if it is clear that in a certain situation you have to plead A, B, and C, and C is not pleaded, and therefore the judge says you didn't plead C, and therefore I'm going to strike this out. That is different from if it is said that it has to be A, B, and C, but now the judge says, but you also have to plead D, and you didn't do that. Would that then make it a final decision? So in the original idea, A, B, C, you didn't plead C. This is clear. So I strike it out. This doesn't seem to me a final decision. It seems well, a preliminary issue that is dealt with. But if it is that normally you would require A, B, and C, and now the judge says as a novelty, okay, but I also think it should be D. In that case, you are saying that changes the situation. In that case, you really go into the merits without going into the merits, but basically that's what you're doing, and therefore it's a final decision. Do I understand you correctly?
Yes, Your Honor. Essentially, yes. So, like I said before, we understand if the judge says, look, you were supposed to join the right parties. You were supposed to do it within a certain time. This specific type of offense requires this specific pleading, and everybody knows that. It's clear. But when the judge is basically asking for his opinion as to what should be in a pleading, that's something else entirely, or for evidence. And that's something we could never meet that standard. It's impossible. It's impossible.
You could have even a discussion. Let's say, okay, the judge now says you also have to plead D. That, you know, from the point of view of the jurisdiction, you could say, well, that was wrong, or that was manifestly wrong. You could make all kind of nuances in dealing with that. You would agree to that?
No, I don't understand, Your Honor. I don't understand.
Well, something can be wrong according to one party and right.
Yes.
But there are certain wrongs that are manifestly wrong.
Correct.
So that could be a nuance that you could also take into consideration. And I understand that you also referred in the court below to a decision of our court in the case of John.
Yes, Your Honor.
And Plico. What does that case say according to you?
Right. I don't think I relied on that case in this instance. It's actually a case I was involved in. But I remember in that case, though I think I relied on it for two reasons. Number one, because part of our issue has to do with the public importance. Okay. And in that case, I know why I didn't rely on it this time, because it was something I remember that the justices had said in court that did not make its way into the decision. And it said that it's such a public importance matter that it's worth hearing, because I think they had made the same argument about interlocutory and final. Okay.
Yeah.
But this one wasn't an election petition, so I wasn't sure we could use it again. But the other issue, though, that one of the things I remember from that case is that there was the court made a determination that the decision was final, because even if it started off as an interlocutory matter, because the substantive merits of the case were agreed.
Yeah, as you're saying, it was not an election petition, but
no, it wasn't. It wasn't. But, yeah. Okay. But it was relevant, though, I think, on the issue of interlocutory and final, because we did go back and forth on that. And the court said that the substantive matters had been agreed. In other words, that was already established. So we know what the substantive issues are, and that's what makes it final. And so again, it's consistent. Substantive issues, if they've been canvassed, and remember, the Nevis administration case doesn't just talk about determining substantive issues. It talks about canvassing substantive issues. Once you've touched on them, that's a final decision. And I just want to there's so much. I don't know if I need to go into. I'm sorry. Excuse me. If I could just consult with my junior. I'm sorry.
Yes. Go ahead.
We have not brought it up. Okay. So, Your Honors, in my submissions, at paragraph 55 to 60, we go into all of the case law where it's very clear that the judge should not be asking for evidence, Your Honor. So even the question that was put to me when I was going through the revised list about, well, maybe he just wants us to say on the pleadings a bit more and so on. The case law is very clear that we can just say a teeny tiny bit of stuff. All this detail is not necessary. Have we identified a cause of action?
Mr. James, can I ask you a question on the revised list?
Yes.
Is your position that the revised list, without any proof, let's say at a trial, without any proof of impact on outcome, is sufficient in and of itself to vitiate an election?
Yes, Your Honor, and I will tell you exactly why we say that. I would like to take the court, if I may, to that Mark Brantley case. Paragraph 76.
All right, so before you go there, is it then that before us, on that single ground alone, you say the unequivocal evidence is that there was no revised list published or used in the election? You say you pleaded that clearly and that the judge recognized that.
Correct.
So if that is correct, where we'd have to decide whether it is sufficient, on that ground alone, what is the impact on whether on what should happen on this appeal? Suppose you are right on that. How does that affect this question that Justice Witt raised of final interlocutory and or what should be done? In other words, what you are saying is that there was a fundamental error of law, i.e., the trial judge on the clear law, let's assume this is a position.
Right.
The clear law is that non-reliance or use or publication of the revised list as required by law vitiates an election, full stop.
Yes, the clear law is that, yes.
No. I'm not trying to ask you whether that is a clear law. I want to ask you something different. If that is so, but the trial judge, in an error of law, struck out the petition. That is, the trial judge made an error of law, said no, not insufficient. That's an error of law by the trial judge, right?
Yes, Your Honor. That's an error of law. Yes.
But what I'm trying to ask you is, does that make the decision final?
Yes, it does, because the judge did not just strike it out on an error of law. The judge made substantive findings.
No. I'm trying to narrow this. I'm asking you about one thing only. Assume the only ground in your appeal was the revised list ground. Suppose that was the only basis of this challenge. Nothing else.
Yes.
All right. If it is that the judge said he struck it out because that is not a sufficient basis, because he said, for example, there was no pleading that had a material impact on the outcome of the election. Suppose he said that. What I want to ask you is this. Would that make the decision final and not interlocutory, and or will it allow you to appeal?
Our submissions is that it makes it final because it's a substantive finding on the use of the revised list or the non-use of the revised list. And I am hesitant, Your Honor, with respect, to go into any more what ifs because we have to deal with what's before us.
No, I understand that, Mr. James. I am not, don't misunderstand me. I am not trying to in any way minimize your case. I'm trying to clarify something in my own mind.
Yes.
So you say it would be final because it dealt with the issue substantively.
Exactly.
But if the judge has held otherwise, the petition would have gone forward.
If he held otherwise, Your Honors, if the judgment had held otherwise, the petition
on the revised list point, I'm still on the revised list point.
It's a substantive matter. It's a substantive finding, and that's what the Kenyan case is saying, and that's what all of the case law we've relied on is saying. He's not dismissing the case for want of a cause of action. You see, he's dismissing the case.
He is because he's saying the revised list argument has two limbs. I know this is a little hypothetical, but just bear with me. He is saying the revised list argument has two limbs. A, not only must you show there was no use, publication or use reliance on the list, but also B, you must also show impact on outcome.
Right.
Now, you say that second element is not necessary.
It's not just not necessary. It says, okay, so I think this is where, once we're going into cause of action, I think that's why I made the point that none of the cases relied on by the Court of Appeal or the respondents were struck out on the cause of action limb. Okay, the question of the revised list is not an interlocutory issue. It goes to the substance of the case, whichever way we decide it. So, for example, I relied on a case that speaks exactly to that. It is a Privy Council case, I believe. Oh, sorry, it's the same Nevis Island case where the judge said that the substantive issue had to do with negligence. Okay? And the judge did not touch on any issue that had to do with negligence. The matter was struck out because the parties did not have local standi. Okay? Our substantive issue on the revised list is failure to comply with statute. That is a substantive issue. If the judge says one way or the other, that matter, that is enough ground and enough merit. If he says that there's enough merit in that, that is a final decision. Because it has canvassed a final decision, or something that should be the substantive case. So there's a case called Vehicles Supplies Limited and another. It's at paragraph 46 of my last set of submissions. And it talks about, it's relevant, it talks about default judgments, but it's relevant. And what it says in that case is that if a defense is struck because it's wholly defective, meaning that it's not a good defense, it's struck on the merits, then that's final. Because you're saying you don't have a good defense. What the judgment said is that we don't have a good claim. That is final, because it's on the substantive, it canvasses substantive issue, whether it's on negligence or breach of statute. And I really cannot emphasize that enough, is that I think what I think happened in this case is that there was this issue of whether it was decided this way or whether it was decided that way. But that is not the end of the test. The test is in the Supreme Court Civil Procedure Rules at number 62. Is that, has it canvassed and determined substantive issues? The revised list is a substantive issue and it determined that. So it was final. That is our position there.
Thank you.
My lords, if I can address the court on the issue of the public importance.
I think you are way beyond your 60 minutes.
Yes, I understand your honors, but I really practiced before and I was within my 60 minutes. I got a lot of questions, which I think kind of threw me off. If I could just
10 minutes.
We'll give you 5 more minutes.
Okay, thank you.
That's part of it. But and in those 5 minutes, if you also could formulate at the end what it is that you want this court to decide. Of course, you want us to allow the appeal, but what exactly do you want us to do?
Exactly. What I would like the court to do, well, I'm prepared for that one, but let me just first go to paragraph 93 of my submissions. Okay. And it talks about the importance of elections petitions. Now, this is a case that we relied on. It was a case similar to ours, striking out a petition. And the Court of Appeal, the same Court of Appeal, allowed the appeal on the basis that there was some sort of bias. Now, I don't know what's more biased than what we've experienced here, where a judge relies on evidence and makes all of these different findings that we say are blatantly wrong and per incuriam and so on. And this is how that case treats election petitions. It says at paragraph 35 of that case, an election petition undoubtedly falls in a different category. An election petition is not a matter involving litigation of a private right, in which considerations of justice arise simply as between the disputants with no additional public interest element failing to be considered. An election petition by its very nature is often a matter of great public importance, of great public interest and importance. The right to the hearing and disposal of an election petition by an impartial tribunal is a matter of tremendous public interest. It is also a right which engages Section 8 of the Constitution. The right to a fair trial by an impartial tribunal holds a prominent place in a democratic society, and it is pivotal for public confidence in the administration of justice. There is accordingly an important public interest in ensuring that the administration of justice is preserved from any suspicion that a judge hearing an election petition is not impartial or has premeditated the matter. Your Honors, our submissions is that this judgment, especially when the court goes through all of my submissions and my notice of appeal that was filed at the Court of Appeal, we argue that that makes it clear that this was not a fair hearing. Could not be fair. We didn't come expecting evidence, and we very much expected that at the very least, Court of Appeal decisions will be upheld and followed by a High Court judge, and that when we did everything right, that we'll be allowed to continue to be heard. And yes.
But Madam, a judge who is wrong is not per definition biased or unfair. He's simply wrong. I think you have to have a little more than that. Even if he's wrong.
Your Honors, first, one of the things we do plead is bias in our notice of appeal. There's a section there, particularly with respect to costs. But the other issue is that bias, this section I read is not just about bias. It's about the importance of an impartial tribunal, of fair judgment.
Sure.
And it's not just a matter of being wrong, it's being demonstrably wrong. If a judge is referring to the wrong section of a pleading, I mean, it makes me look crazy that I pleaded section 32. The wrong section of a pleading. If a judge is asking for evidence, if a judge is asking for facts, at this rate, when I read that decision, I thought, well, he could ask for anything. He could say, did I say that Muhammad came to the mountain? I don't know. I felt very, what else do we go? And that's the reality. And I hate having to say it like that, but that's how it felt. And so what the Benjamin Exeter, in my mind, does is that it says, look, you have to, if nowhere else, we have to hold election petitions at a higher standard. And we understand that, my submission is that we understand the judge has a discretion. But what happens when we're being told we have nowhere else to go? And the matter is demonstrably wrong. Who holds a judge accountable? And I'm not going to go through the decision, but there's a case that we talk about in our submissions that speaks to that and speaks to when a judge misuses his discretion, especially on matters where there might not be anywhere else to go. In this case, we say the matter is final for the reasons that we've set out. And we're asking the court that the fair thing to do is to send it back to the High Court for trial. Because the question, the judge in all of his decisions here, it's what I've just read, he identified the cause of action. So that's settled. We're not asking this court to determine if persons are validly elected. We're asking this court to determine that this was a final decision on the question of whether we have raised a cause of action. And that does not offend the Constitution to make that determination. It prevents this court from determining whether persons is validly elected, but not whether we've raised enough of a claim to determine that. So we're asking the court that the fair thing to do is to send us back for trial on the substantive issues on the basis that this judgment clearly identifies cause of actions. And that it doesn't say that they don't know what they're asked to defend. The respondents never said that. There's no abuse of the process. And my final comments on the issue, my lords, is that I really would like to encourage your honors to please focus where I have everything really set out on my my notice of appeal to the Court of Appeal, which is 194 in the bundle, where we really go into all the issues. And I want to be mindful of that because the respondents are going to come with cherry-picked sections of the decision to say that the judge adhered to his mandate. He did not. And everything is set out in my notice of appeal at number 194 of the bundle. Your Honors, unless there's any further questions for me, those are my submissions.
But I thought that we were only looking at the question whether the Court of Appeal had jurisdiction.
Yes. Oh, sorry.
But you want us to go further. You want us to say, well, they had jurisdiction, and in fact, they should have allowed the appeal.
Well, only for practical purposes, Your Honor, because if we go back to the Court of Appeal, then what? It's a final decision. But in fairness, there was no trial. That's why his decision was wrong and egregious, because we're put in this position now. I don't know if the Court of Appeal, in all fairness, without having the benefit of witness statements, disclosure, can really hear the appeal. But we have a decision from Justice Glasgow as if he's had disclosure and heard witnesses and heard evidence. So that's where we kind of get in a complicated realm. So that's why I've suggested that we go back to send us back for trial.
Without prejudice to anything you've said so far, Ms. James, of course, there are certain practical implications of what you're asking. Yes. These elections were held in 2019 December, so 2 years have gone. Mm-hmm. And then the route that you're inviting the court to take, I suspect will take some time if the court was minded to go in that direction. So there are certain practical implications of what you asked for.
So practical implications in terms of time?
Yes, and in terms of the duration of the government, which is, I gather, for 5 years, and already over 2 years have gone. I don't know how long this trial process that you envisage would take. There is trial before the High Court and then potentially one before the Court of Appeal. Mm-hmm. I'm just thinking that there are practical implications as well.
But Your Honor,
and of course, as I said, this is without prejudice to anything you have said earlier. Yeah.
Yes, Your Honor, I appreciate that question, and there's a couple of things I'd want to say to that. Number one is this matter was supposed to have been heard immediately. When we first filed these petitions, I traveled from Barbados to Dominica on 2 occasions, and it's in the documents, it's in the court documents, practically begging for a hearing date and for case management. I don't think we came on for another 3-4 months, and then this thing dragged on. It's just the way it's done. I think what's important is that we clarify the law and that things look fair. And if it takes a long time, hopefully on the next occasion it's not good. That wouldn't happen. My major concern is that there will never be another challenge to election petitions ever again, no matter how egregious the elections are conducted, because everybody will be afraid that a judge will just say, okay, you've pleaded the law, you have a cause of action, but did Mohammed come to the mountain? So we're really afraid
Ms. James, you're over time. You're well over time.
Thank you, Your Honors.
Yes, thank you. We take a it's 11:40 now almost. We take a 10-minute break and come back at 11:50.
Thank you, Your Honors. Thank you.
Yeah.
she says, she did give reasons. I can't find the exact page now, Your Honor. But if there was no hearing, like for example, counsel turns up without any submissions or any written or oral submissions, the judge says, look, this thing is nonsense. Throw it out. All right? Or the judge continuously harasses and interferes with counsel, preventing what would be some fair determination, fair presentation of the case, or shows some hostility to the other side, or makes a decision that is so egregiously over the moon, totally unrelated to the pleadings. I think the Court of Appeal says that there may well be situations where that might have been possible.
But not if the judge is simply wrong.
Well, every judge has the right to be wrong.
Be wrong.
I mean,
yeah.
that's the benefit of a discretion. If judges got it right all the time, we wouldn't have the CCJ or the Privy Council. The fact is, judges do get it wrong sometimes. But the question is, whether does getting it wrong make it into a final order, which determine the constitutional question of whether these ladies and gentlemen were validly elected.
Sure.
You know,
sorry, go on.
I just, if you could just give me 1 minute, Justice
Mr. Before you move on, I just want to follow up on that. So that, how would you formulate this exception, as it were? Because it remains technically an interlocutory decision. But you say, for example, it is so egregiously wrong. Is it then that it changes the character of the decision for the application test, or is it that is a carve-out exception to the application test? Sorry?
I think it was actually the Chief Justice's words. I found the page now, so may I read it? Paragraph 31. For what it's worth, Benjamin Exeter is in a sense emblematic of the myriad of irregularities which may arise in the lower court from a judge's treatment of an election petition. Other examples, meaning the bias point. Now, I don't want to give evidence from the bar. I was also involved in Benjamin Exeter, where the judge had expressly asked counsel whether they have objected to him following. And counsel said they had no objections whatsoever, but having lost, first ground of appeal was bias, and the court took the position that he should have recused himself, even without asking counsel if they agreed. So that bias probably went to jurisdictional grounds, as I see it, Your Justice. For other examples of similar nature is a decision arrived at on election petition in denial of the right of a party to be heard or the right to be represented by counsel, or where there is some actual bias on the part of the judge. It may well be, so it is important for me to read it, Justice Jamarega. I may have misrepresented what she said. It may well be that these matters can be investigated by way of some alternative route of challenge. For the purposes of the question before us, though, I need not express a view thereon. Suffice it to say that in view of the consistent approach of interpreting Section 40 and the sections across the jurisdiction by route of the election petition, which turns out to be unmaintainable and consequently struck out, there is no right of appeal from such order. So thanks for the opportunity to read it, Justice, so I didn't misrepresent what the judge said. There's one more decision I would like to deal with before I come back to the question raised by I'm so sorry, I forgot the justice's name, that asked about this novel point. Sorry, madam. It's the case of Peter David at paragraph 1373. Sorry, page 1373. So sometimes we get it. This was a decision where a claim form seeking to set aside the election had come, I think, by the wrong process. And it was struck out in full. And at paragraph 7,
And what is the page, our page number?
1377, Your Honor.
1377, okay.
Yeah, for hours. He says, as he says, at paragraph 6, I'm very sorry. There are a number of decisions of this court, starting with Sylvester versus Singh and continuing through to Pirate Cove Resorts and others versus Euphemia Stevens, Jean Marie, and so on, to name a few, in which this court has taken a position of preference for the application as opposed to the order test, in determining whether an order of the court is interlocutory or final. As determined, as stated above, the application before Benjamin was on a strikeout and not on a hearing of the substantive matter. Had the applicant to the application not succeeded, then clearly the court would have had to continue the hearing of the substantive matter. That's really the core question on the jurisdictional issue. Core question. He cites Rollins J.A. and he says in paragraph 8, it is clear that no other conclusion than that the decision of Benjamin J. was other than a final decision, as referred to in section 37.7 of the Grenada Constitution, is consonant with the many decisions in this court, of this court. May I then take the court finally on my journey through the cases to the decision of the Chief Justice in this case, which is at page 1285. And I would like first, before I get to the application test, to address the question and the unfortunate response from counsel on the approach to the court, to the Court of Appeal on the approach to the judgment. I will merely point out before I do that, that at paragraphs 10 to paragraph 15, that's at page 1298 to 1301, she dealt with the question of an application test or the test interlocutory, and throughout her discussion, she repeatedly refers to the concessions and agreements of the applicants in this case, that a strikeout of a petition on pleading grounds or sufficiency of pleading was not a final order for the purposes of the appeal. And therefore, she found it necessary, that is, counsel for the other side found it necessary to craft the case concerning determination of the issue. Now, the question that needs to be responded is, what were the substantive issues that were determined by the judge on the evidence and on the merits? We don't know. We see detailed grounds of appeal. In our written submissions, we have set out in full numerous examples of the judgment of the court, of the judge, where he repeatedly said that he was not considering the evidence, that his focus was on the petitions, and where he said matters concerning the pleadings that were left out by the applicants in their application to the court. These are set out in red and others are not in red. So if I may then go to paragraph 17. He says, at paragraph 17, the Chief Justice sets out the submissions of Ms. James, which were repeated in this case. Paragraph 19, she refers to the submissions from the respondents. Then at paragraph 20, she said, it is, however, necessary for me to make a finding or the other question as a tool for now. The law is that James has argued, I am not of view the learned judge determined the matters before him in such a way that could transform his decision into a final decision. Important word, within the meaning of sections 40, subsection 6 and subsection 7. Now, your lordships have been asked I think, to say, well, the Chief Justice just made that statement. She didn't really look at the judgment and so on. It's astonishing. At paragraph 21, the Chief Justice said, at paragraph 5 to 25 of the judgment, the judge set out in summary form the allegations and the principles to be set out, to be dealt with by him. At paragraph 22, the Chief Justice clearly identified the two questions which the judge says that he had determined, none of which dealt with merits or evidence. On paragraph 23, as to the pleadings question, the judge considered firstly in relation to the nomination process that the petitions had failed to plead the nexus between the alleged irregularities in the nomination process and the outcome. She then quotes at paragraph 112 of his judgment. And in the last sentence, that evidence is not required at this stage, but the respondents would need to know in what manner the results were rendered safe and void. When you read the preceding sentences, the judge was clearly referring, you need to know the nature of the case from the pleadings, not from evidence. And he said the pleadings must go on to show, and so on. She goes to the paragraph 24. The judge at paragraph 118 points to a number of matters which in his view ought to have been pleaded, which rendered the petitions defective. Now, I think a judge clearly has jurisdiction to say, as pleaded, it is insufficient. Or he can put it in the positive. He can say, for the pleadings not to be defective or to be sufficient, you had to go on and plead either material facts to show that the result of the election may have been affected, or that there was such non-compliance with the law that the effect was that the election was a sham. Your Honors, the test in the English common law cases which applies to Dominica is that the pleadings must at least point in the direction of a sham. Morgan and Smith and all of the others that were cited by the judge. And the Chief Justice says, the respondents claim that the evidence contradicted the allegations relied on and so on. The learned judge was careful not to consider this evidence. The judge said, I refrained from going down that road into a discourse on the factual disputes. Your Honors, he said so more than once. Then the judge goes on, the Chief Justice and this is where I think I have to come to the defense of the Chief Justice and the court and read one more paragraph at paragraph 25. She says, she refers to the judge's reference to a number of complaints and so on. She said, I will not reproduce almost all. I will not reproduce the trial judge's reason at each point, as I consider the above quotations in the judgment as representative of the approach he took in the pleadings in the context of the respondent's application to strike. This actually identifies the paragraphs. These portions of the judge's judgment are found, for example, at paragraphs 121 to 127, 130, and so on. Then she goes on at paragraph 26 and holds, the learned judge was careful to hold faithfully to his remit on the applications to strike. The learned judge made reference to more than one on the learning. The trial judge refused to consider the affidavit evidence before him and went to the merits of these are findings of fact by the Court of Appeal. He took the pleadings as true so as to determine whether they were, in his view, sufficient to sustain the particularized case. In my view, the judge did not step out the permissible grounds of the court on an application to strike. And Your Honors, with all due respect to the applicants, I have heard nothing from them this morning which suggests that the decision of the judge is wrong. There are some other matters that I wanted to touch on. I mean, we are simply on the basis of the jurisdiction point. This is not a merits case. This is simply whether or not the Court of Appeal was right to have exercised its jurisdiction. I will draw a classic contrast, if I may, Justices.
Mr. Osman, before you do that, you were just reading paragraph 26. In my view, the judge did not step outside the permissible bounds of the court on an application to strike. So then I asked myself the question, what if he did step outside those permissible bounds? What would that to the decision? Would that make the decision final?
It would not. It would not. Your Honor, it would not make it a final decision because the constitutional jurisdiction, the boundaries of its jurisdiction, it's not just a final decision, but it's a decision which determines the constitutional question. And simply because that you don't have a sufficient cause of action to go to trial for the purposes of a determination on the merits, which is required or would be required to make a determination unless there's an admission across the board. Striking out somebody's petition, even if you may have erred on an error of law or a mistake of interpretation, would not transform that decision from what is clearly an interlocutory decision into a final one.
So you would answer that question by saying, well, even if the judge did step outside the permissible bounds of the court on an application to strike, that would not lead to jurisdiction for the Court of Appeal.
I am saying that, and I'm also saying as well that once the judge focuses on the pleadings, once he focuses on the pleadings to come to the determination that they're unsustainable, if he were to make, say, for example, the example given by Justice Jamada, an error of law on the question of the revised list, that would not transform the entire decision into a final decision, which has determined the constitutional question. Because one error or two errors, we respectfully submit, are wholly insufficient to transform the nature of the. Had the judge gone on to say, look, this thing is as it is, as a result, he doesn't order that the petitions are struck out, but he orders that the first petitioners are therefore lawfully, validly elected. That would be a crazy decision for any judge to make. Mm-hmm. But I have said not even that. Well, perhaps that may be a critical question of jurisdiction, because a judge at that stage has no jurisdiction to determine whether somebody is validly elected on the issue, on the application of a strikeout.
But he didn't have to say that. It would be simply the effect of his decision to strike it out, correct?
No, I completely disagree that that would be the orders test. That would be the consequence of the orders test. But if you apply the textual approach by Sir Dennis Byron, Sir Brian Alleyne, whether you use the application test or the order Test, to me, Sir Brian Alleyne is of no moment. My textual construction.
I mean that if the judge strikes out the petition, that's the only thing he does. But the effect is that that particular election is now certified in a way. He doesn't certify it, but if there is no further petition, if it is struck out, then clearly the one who is elected will go to Parliament. Isn't that so?
I disagree with it to this extent. If that's the approach taken by the court, or by any court, you will be introducing the order test through the back door.
No, I'm not talking about order test or whatever. It's just simply making the point that would be the effect of striking it out. Doesn't mean that it.
No, I completely disagree, Your Honor. The effect of a strikeout, where there's an insufficiency of a cause of action, is that the petitions are not valid and do not raise issues to be triable. We need to go on to also consider what would have been the consequence of the judge ruling in favor of the applicants. Then it would have had to go back to trial. And I don't think on one side of the fence you can say, well, it's final in the sense its effect is to determine the question. And on the other effect, had it gone the other way, then there would have been clearly no effect on the constitutional question, but that question would have to be determined by the court.
Sure, I'm not saying that would have any bearing on the question whether it was a final decision or not. But it's simply a fact that if there is a petition, election petition, and it is struck out for whatever reason, that is the end of the story. I'm not saying that that would then make it a final decision where that could be appealed. I'm not there, but I'm just making the point
that if there was time, if there were no time,
if there was time, yes,
then they could bring it back. So that
Sure.
is not the end. Is not necessarily the end. It is only the presence of time bars that makes it effectively the end.
Yes, well, I'm not talking theoretically, but of course in practice that I think it's 21 days I heard, so it will rarely ever be decided within the 21 days. But beyond that, the effect is that, well, the election cannot be further.
Your Honor, the reason for the time bars, if I may interject in this here, as has been set down by numerous decisions of the Court of Appeal in our jurisdiction and by Sir Hugh Rollins in particular, that it is precisely because of the 21 days, or put it straight, the Parliament insisted on the 21 days for expedition and everything to be crystallized to get to trial and so on and so on and so on. And he's also said that in considering all of these questions, the question of expedition and certainty must be clear. And this is why he is one of, as a High Court judge, started the jurisprudence in this country that says election petitions must be clearly, precisely, and sufficiently pleaded within a certain time. And after 21 days, you can't bring it back or amend it or whatever have you. So, but I think
that makes absolute sense, because yes, if this is to be decided years later, then it really misses the point.
Well, the same effect would happen if petitioners are allowed to appeal every decision of a High Court judge.
Sure.
Regardless of whether it determines the constitutional question or not. Then we're back to opening the gates. I know in having reread the judgment of the court in the last occasion that I appeared in, I understand the point the court was making about the two gates. But we are concerned only this time with the one gate, which is the construction of the rules governing election petition. Mr. President, may I just have I'm almost finished. I'm going to ask for turn off my mic to talk to my team in Dominica. I would like to raise two questions briefly, where I think the court, I have to ensure the court does not get taken down. I want to refer the lordships to the Parry case. The Parry case, which is going to be important to the question, Justice Ramadan. I also appeared in that case. So unfortunately, I'm familiar with it, having lost. I'm just trying to bring some humor in the material. It starts at page 1879 of the Applicants Submissions Authorities. But I can briefly tell you about it. This was a case where the petitioner, through the excellent work of his legal team led by Douglas Mendez, SC from Trinidad, was able to establish fraud, bad faith, misfeasance in public office, and even ordered damages to be paid against the registration officer, because the High Court had found, and the Court of Appeal agreed with the High Court judge, that they had acted with the deliberate intention. This wasn't just a mere contravention of the law, as happened in this case, without express pleading, with the deliberate intent to deprive over 300 registered voters of the right to vote. They did not send out notices of objections. They did not publish the revised list deliberately, because then the over 300 people, some of whom in the diaspora, would not have known that they'd been taken off the list. And the court found as a fact that had a direct impact, as pleaded by Mr. Mendez, on the result of the election because the number of persons that were deliberately and fraudulently removed from the list was over 300. The respondent won by about 10 votes. So we can't just, by a process of osmosis, rely on a case that said the mere non-use of the revised list rendered the election void. That is not correct. There was no such finding in Barry. The finding was that there was a conspiracy to defraud electors of the right to vote. I mean, I don't have the time to take it up, but the court found as a fact that there was misfeasance, malfeasance, all sorts of things, bad faith. On the question of the access to the media, your honors will see that at page 86, at paragraph 51. Parry held that the denial of the right of access for Mr. Brantley constituted a contravention of his fundamental rights of expression and not to be discriminated against because of his politics. It did not find the mere misuse was sufficient to vitiate the election in the country of, what they call it, Nevis. This is why in paragraph 90, when Justice Don Mitchell summarizes his thing, he says, look, I would similarly dismiss the amended appeal brought by Mr. Benjamin and Ms. Lord as I would uphold the declaration of the learned trial judge that held was invalid and void. I'm taking my time to get the point across, Your Honor. Quite apart from it, on the basis that the applicants failed to act in accordance with the principles in the law, acted improperly and unlawfully, and as a result, the election, that's at page 1932 of their authorities. As a result, the election was not substantially conducted in accordance with the law, and the irregularities affected the result of the election. If I may then ask the court to have a look at, so the court did not find the mere non-publication of the list affected the result of the election. In Ferdinand Frampton, which they relied on, I just need to make these additional submissions because I think the assault on the judge was unnecessary. It starts at page 1715 of 2292. And this is where the misunderstanding on the part of the applicants occurred. The petitions that's in the Frampton case seek to impeach the Dominica Broadcasting Corporation. They allege that the governing Labour Party abused its position as the party which formed the government. Fast forward, that the alleged abuse of the DBMC by the DLP, not the government, not the ministry, not the permanent secretary in the Ministry of Information in Nevis, by the DLP in favor of its candidates, including the first responder, meant that the May 25, 2005 elections were not democratic. Paragraph 33. The learned counsel for the petitioners, Mr. Ford, cited the case of Ego Dowell versus Commission of as authority for the grant of a declaration that the misuse of the state-owned radio for campaign purposes by a political party contravened the constitutional right of freedom of expression and thereby vitiated the poll. That was the submission that was made, Your Honors. So I don't know if it was Justice Rollins, as he then was said in Angola, the High Court of Sri Lanka did this. It stated that one of the safeguards of a genuine democratic election is to ensure freedom of expression, of the safeguards of to ensure genuine election, to ensure freedom to campaign on equal terms. He says number 34, he makes no statement about setting aside the election as void. It was the submission made by counsel representing the applicants. He then says a state-owned and operated broadcasting media is not the preserve of the political parties. It's there to serve the people of the country. Then he turns at page 35. In order to obtain the declarations, not order setting aside the election, the declarations concerning the alleged misuse of DBS, the Attorney General is an essential respondent because the declarations will be against the state for the infringement of a constitutional right. I mean, that is what he said. But in this case, Your Honors, when you look at the grounds of the application for special leave, you will see that the applicants say that they relied on these cases to set aside the elections as being void. It's in their case. But that's not what the case is decided. This is why the judge said, and I'm sorry if I'm trespassing into the merits, but I think I need to make some statement on the record about it. I'm not sure what page I have it on. Can I have a minute to just check my papers, Mr. President? Just 1 minute. Yes, this is why we submit that if you're going to make the allegation about setting aside of the election, you had to plead a number of things. At paragraph 158 of the judgment, which is at page 2656 of 2686. He says, I fear that I must agree with the respondents' applicants on this point. The learning extrapolated from Ferdinand Frampton and Joseph Parry informed that the petitioners may plead and prove a deliberate breach of a state entity collusion with an insistence of candidates and or the agents of a fundamental right that affects the constitutional right to vote. And he got that for discrimination and so on. And then he goes on. He says, at paragraph 159, in this case, there's not even the suggestion that there was involvement by the knowledge collusion of any members, candidates, or agents in relation to the impugned matter. And then he goes on to speak about the sham and affecting the result of the election. And we respectfully submit the judge didn't make an error of law here. What he was saying that if you wanted to set aside the election, you had to plead more than a mere breach of a constitutional right of access to the radio. You had to plead some irregularity, some misconduct, something that made the affected the result of the election, and or which rendered the election a sham. And as I've said, Your Honors, there is nothing like this in the petition. This is why, if I may then go back to paragraph 130 of his judgment on the revised list which my learned friend spoke of and Justice Jamada spoke to her about. The true concern, in my view, quite frankly, that confronts the pleadings is the manifest lack of reference to whether this purported breach of Section 70 had any impact on the election. And if so, in what manner did it impact the results? Questions that arise should have been addressed on the pleadings, not the evidence. Pleadings are whether the breach amounted to an election offense, irregularity, if so, whether and how it affected the result of the election. If the alleged breach did not amount to an offense or irregularity, the question arises whether or not it is such a substantial departure from the norms and dictates of the election law sufficient for the court to set aside. My lord, that is precisely the clearest application of the law to the pleadings in an election petition. That's not an error of law. And the applicant's reliance on Joseph Parry is completely misconceived. there were findings of bad faith, fraud, and misfeasance in public office that had the effect of depriving over 300 persons of the right to vote. So, Your Honor, Mr. President, may I just have a brief call with my team in Dominica? I don't think I'll be more than another 5-10 minutes once I speak to them, if at all, anything else.
Yes.
So I can just turn off my mic and just have the quick call. Lennox, please put your thing on mic. Let's chat.
It has to be quick.
Mr. President, will be very quick. I hope that's quick enough, Mr. President.
Let's proceed.
Mr. President, my final comments are that the judge properly exercised his jurisdiction to strike out the petitions on the well-recognized principles governing pleadings in election matters. The Court of Appeal properly exercised its jurisdiction by refusing to hear an appeal from a decision that was not a final decision, which determined the question as to whether or not the first respondents were thing. And we have to say, in conclusion, that we remain uncertain as to which were the merits decided on the evidence, because there were only, I think that there were on the record, and you can see from the judges, there were only 2 instances in which evidence was tendered before the court, and that was in relation to abuse of the process. At page 108 paragraphs 119 and 121 of the judge's judgment. I would very much like to end on that and one other paragraph.
What paragraph, Mr. Aston? What paragraph?
119 Justice at page 2638. He says, the respondents' applicants have filed evidence of numbers produced from the Office of the Chief Registering Officer. They claim that the numbers contradict the allegations raised on the petition and as such prove that they're patently wrong and an abuse of the process. I refrain from going down that road into a discourse on the factual disputations. A number of, meaning the conflict between the affidavit evidence and the pleadings. A number of authorities have instructed against the practice of conducting a mini trial on a strikeout application. What does concern me, meaning the judge, is the patent lack of specificity or precision on the pleadings in the manner I have stated above. In particular, the pleadings, the petitioners are required to plead sufficient material to demonstrate how the breach of the law on the determination of claim may or may not have affected the result of the election. And then he says, the pleadings do not meet that standard. Paragraph 121 on page 2640. He says, about halfway down paragraph, what you said, he said again, I refuse again to enter the dispute on these matters, which is the conflict between the pleadings and the affidavits. The court scrutiny is to ensure that a properly pleaded case is set out on the petitions. Arguments about issues and varying interpretations in question are hardly suitable at this junction. To entertain the varying disputes would, in my view, enter the realm of the sort of discourse that is expressly frowned upon in the authorities. And he cites the authority. And then at paragraph 67. At page 2611 of the judgment, he says petitions may be perfected in the sense that they contain a sufficiently pleaded cause of action and be filed within the statutory period. No extensions of time to do so are permissible. The court will err on the side of permitting it to proceed once it contains sufficient facts demonstrating the cause of action. As I said in Lonro, PLC versus Fire, the court's role is limited to scrutinizing the statement of the claim, in this case the petition. Evidence for and against the facts set out herein is inadmissible unless the court finds in exceptional cases that the pleadings amounted to abuse of the process. And he found that there was no abuse and there was no need to consider the evidence because he was concerned solely with the question of the. So we respectfully ask the court to reject the case of the applicants, that the judge not only was not that the judge merely being correct on the pleadings is not enough. He went on to make findings on the evidence and substantive decisions, and we are not sure what decisions these are. A judge who says that pleadings are inadequate, what needed to be done is A, B, and C, is not making a determination of the issue of bribery or treating, whatever it was. A judge who says, look, on the mere contents of the provisions of law, your petition does not meet the test required under the law, or that your pleadings do not meet the test that the precedents have set as to the precise particulars required, and in particular, whether or not the materials, the irregularities may have affected the result of the election, or that the election was a sham. So, Your Honours, these are our respectful submissions. If there are any questions, I would very much like to respond to them.
Yes, thank you. Ms. Evans, do you wish to address us?
No, Your Honours.
Yes. Mr. Peters?
Well, only to the extent of adopting the submissions made by learned senior counsel and to draw the court's attention to the Court of Appeals, the paragraph 4 of the Court of Appeal, where the Court of Appeal set out before substantive areas of it that it held. And at paragraph 4, I think in terms of the particular matter that we're dealing with here, stated the public importance attached to election petitions cannot be a basis for assumption of jurisdiction to hear an appeal, but substantively, and what I submit is of relevance, and I would wish to adopt, as it were, in this matter. It goes on to say, it is simply not open to the court to arrogate unto itself jurisdiction to hear an appeal when no such jurisdiction has been conferred upon it by either statute or the Constitution. The Constitution's provisions are clear and have been consistently interpreted to exclude appeals in the nature of the present appeal. In all circumstances, the petitioners do not have a right to appeal against the learned judge's decision, and the Court of Appeal, as a consequence, has no jurisdiction to entertain the petitioner's appeals. Your Honours, I submit that that is a clear and succinct statement of the position in this matter. In spite of all that has been said to this court, the fact remains that the Constitution is very clear on the process and the manner in which an appeal can properly be brought in an election petition matter. And as the authorities are clear, election petition matters are a special jurisdiction. I invite the court to, similarly to the Court of Appeal, find that in this matter, the Court of Appeal correctly came to the conclusion that they had no jurisdiction to hear the appeal that was sought to be brought by the applicants in this matter. My Lords, I thank you.
Yes, thank you. Ms. James, do you have a reply?
Yes, my Lords, but I'm going to be as short as can be because I think I've addressed most of the issues raised by counsel. I do think it's important to quickly clarify the case Joseph Parry, because I'm not sure why. And it's in paragraph 8, just a very brief paragraph. I'd just like to refer the court to paragraph 8 of the Joseph Parry decision. I think
what's our page number?
Yes, your page number. Well, the case itself is at, the Joseph Parry case itself is at 1879 of the bundle. And I'm looking at paragraph 8 of that case on page 6. And it very succinctly says, the list used for the July 2011 election was not the list required to be used by Section 48 of the National Assembly Act. The list was to comprise the register of voters and the revised monthly list published under Section 43 and 45 of the Act, together with the May monthly list. The election was accordingly held on the basis of a defective list, and on this basis alone, the petition ought to have succeeded. And that's the law. Everything else that was determined in that case about any corruption, further corruption, was matters that came out in evidence that were relevant to that specific case. But the ratio descendi, or I hope I said that correctly, the ratio of the case was that the revised list having not been used alone vitiates the result.
And that is it where you said?
That is at paragraph 8 of the case, and the case itself in the bundle is found at 1879 of that decision. Of the CCJ bundle, paragraph 8. And it's also in my written submission.
Ms. James, just a pause for a minute. So in the classic language of election petitions, would you put that in the category of it therefore rendered the election a sham? Because there are a few general grounds, you know. Mm-hmm. The election was a sham. Of course, the irregularities, if there are, it's not sufficient. They must also impact the outcome. So are you saying, therefore, that this situation of the use of a defective list is sufficient alone to vitiate the election because it would have rendered the election that was held a sham election?
Okay, I'm sorry if I have a slightly longer answer to this question. Yes,
sure.
But we've pleaded yes that rendered the whole election null and void. It's in our petition. But also, Your Honor, you might recall we referred to the case Morgan and Simpson, and it's in Justice Glasgow's decision. And he lists what the criteria is for vitiating a result, right? And so there's several factors, not just the one I referred to, but it speaks to irregularities. So you might, what we had said in the High Court, and this is me not wanting to give evidence, but our position is, I can say it now, is that there were so many irregularities that taken together, the whole election was a sham. And so together or individually, however the court wanted to use them. Some of the irregularities that we pleaded, on their own, you might say, not so much. But when you put it all together, it was a sham. But certainly with respect to this particular pleading, absolutely a sham. Because what they said in this Brantley case was that not using the revised list alone vitiates the result. And it makes sense because your list is the thing that determines who votes. And if you're using the wrong list,
Yeah,
then you have a problem.
Thank you, Ms. James. Yeah.
Okay, thank you, Your Honor. I'm sorry. And then the other issue, I think in his submissions, Mr. Asafan actually made the point for us. He referred to the Ferdinand Frampton case, which spoke to DBS, the use of the same DBS radio. By the way, they've been doing this for years. They've been accused of doing this for years. We did 4 pages of how they misuse their power. 4 pages. So to say the pleadings were scant is not true. And the judge, Justice Glasgow, accepted that evidence was there and it should be taken as true. The case referred to was Ferdinand Frampton and Joseph Parry. Ferdinand Frampton was the original case that came out of the High Court at the time that said if you don't use the state, if you misuse the state radio, it vitiates the poll. I heard counsel say that. It vitiates the poll. In Mark Brantley, it referred back to that case and it did not overrule that section. It did not overrule it. So the issue is that when a political party in power contravened the state, let me slow down. State-owned radio for campaign purposes by a political party in power contravene the constitutional right of freedom and expression and therefore vitiate the poll. So in Ferdinand Frampton, it accepted that misuse of the radio vitiates the poll. I expect that your honors, that you will read the case for yourselves and satisfy yourself. The last thing I want to say is that the Honorable Mr. Justice Witt kept making references and asking counsel what happens when a matter is demonstrably wrong, when it's incredibly wrong. And that is answered by Justice Pereira herself in a decision that we refer to A and E, A and others versus E at 1697 of the bundle. Okay, at paragraph 8, page 7 of that decision. It's in our bundle. And one of the points that she makes, she speaks about when a decision is per incurium, okay, when it's a wrong decision and what the court should do when it determines that. And this is what Chief Justice Pereira says. She says, what are the guiding principles on which the court may conclude that a prior decision was given per incurium? Examples are usually given and cover cases in which the court has acted in ignorance of a previous decision, of its own, which dealt with the matter before it, in which case it must decide which case to follow, or where the court has acted in ignorance or forgetfulness of the terms of a statute or rule having statutory force or some inconsistent authority binding on the court, or where, in rare and exceptional circumstances, when it is satisfied that the earlier decision involved a manifest slip or error, and there is no real prospect of further appeal to a final appellate court. What the decision is saying here is that even if a matter, this is my interpretation. Let's say we say this matter is interlocutory, which we say it's not, but there is no further appeal. And you have all of these blatant errors, which, by the way, all of which we've alluded to in our application. Then that's when a matter is per incurium. And then finally, I'm not going to go into the whole decision, but there is a case we relied on which talks about when a matter is dealt with, when a judge misuses his discretion. It's at paragraph 74 of my submissions. And the case is Charles Austin and Company. So it's a West Indian case. And again, they mention in that case that when the judge is, you do not interfere with the discretion of a judge unless the court is clearly satisfied that he was wrong. But the court is not entitled simply to say that if the judge had jurisdiction and had all the facts before him, the Court of Appeal cannot review his order unless he is shown to have applied a wrong principle. The court must, if necessary, examine anew the relevant facts and circumstances in order to exercise a discretion by way of review, which may reverse or vary the order. Otherwise, this is the part. Otherwise, in interlocutory matters, the judge might be regarded as being independent of supervision. And that is why we're here today, Your Honors. We need to know that there is supervision, even if the matter is considered interlocutory, which we say it's not. This decision was wrong.
Just a minute. How do you define the line between errors, even patent errors, in an interlocutory decision, clearly which is not final because it's purely interlocutory, on the one hand, and decisions which are final and therefore are appealable. Is it dependent on the nature of the error? Is it dependent on the extent of the error? Or how do you characterize when it says decisions are appealable if they are final, where the question which is really in issue, whether these people were validly elected, where that question is not addressed. But before the judge reaches to address that question, the judge erroneously ends the proceedings by findings which are erroneous. In what circumstances are those decisions appealable, even if those decisions have not addressed the issue of whether the people are validly elected?
Your Honors, the decision of Justice Glasgow does not say these people are validly elected, but that's the effect. Because he did go into issues of evidence. This is our submissions. Otherwise, what we say is that it's for us as officers of the courts, and especially at the apex court, Your Honors, you all, you are the guardians of democracy in the Caribbean and of fair elections. I'm sorry, fair hearings in our jurisdiction. If the court, our submissions is that any court looking at what was said and what was done and what was decided by Justice Glasgow, I don't want to say what you should do. I don't want to go that far, but our submissions is that we would, and our submissions are that there has to be a determination that we just could not win this case. It was so incredibly unfair because it was wrong. The use of the law, it's clear that the use of the law was wrong. The application of the law was wrong. There were errors of fact, there was errors of law, and there was disregard. There were errors of law and there was complete disregard of what the law is that the judge was entitled to follow. And that is set out in the ruling of Justice Piera that I referred to when she said, this is when we can decide a matter is per imperium. And it's for the court to decide, have they gone too far? Have they really not applied the law? We think that that's clear. But most importantly, we did set out the test for when a matter is final, which is have you canvassed, not just determined, canvassed the substantive issues. And we think that the judge has done that. And then in those circumstances, that test is there for a reason. And we cannot ignore the fact that there is a test. There are requirements that the judge had to follow that weren't just up in the air or open to a judge's discretion. We know he's not supposed to ask for evidence. We know even the scantily clad pleading should go on to trial. And we know that that is not what the judge did. And very importantly is the overriding objective. And I know that the courts tend to get frustrated sometimes when counsel just refers to the overriding objective. But there's and this is where I would like to end. At paragraph 110 of my submissions, I refer to a Court of Appeal case that says, there is no discretion vested in the court to determine whether or not it will give effect to the overriding objective when dealing with cases. The language of the rules mandates the court at all times to be alive to the overriding objective and its effect on the exercise of discretions and interpretation of the CPR. And so that's where we want to rest, your honors. We're imploring the court to at least clarify what happens in these circumstances, so that we can be confident going back to the polls in the next 3 years that the officials of the election will use the revised list, that the state radio will not be misused. Because if we're not clear in this decision, I don't think we're going to have fair elections in Dominica again. And if we don't, nobody will challenge it. Thank you, Your Honors.
Yes,
Mr.
thank you very
President,
much.
may I just have 1 minute to clarify something? I know I'm not entitled to any response, but I need to clarify something. My learned friend referred to head number 8 in the Parry case that says the failure to use the list, defective list on the basis alone these petitions ought to have succeeded. I would ask the court respectfully to have a look at paragraph 34 and 77 of the judgment. Your honors will find that the Court of Appeal made a decision that the mere failure to, quite apart from bias and misfeasance, the mere non-publication of the list has led.
Stefan, what are the 2 paragraphs? 37 and what?
34 at page 1902.
No, just the paragraph. 34 and what?
And 77 of the Parry judgment.
All right, thank you.
Where it says
that's it. That's all you need to tell us. Paragraphs 34 to 77. You, as you correctly pointed out, you don't really have a right to rejoinder. Would you all stay on the call? The bench is going to confer for a few minutes, and then we will come back to you.
Oh God.
Justice Jamada, you're still with us.
You want me to leave or and come back?
You may need to go with the bench, but we are seeing you, and we don't. Good, thank you.
The court will take time for in this matter, and we would let you know due course when the judgment will be given. So the judgment is going to be reserved, and we'll endeavor to give that judgment as soon as practicable. I want to thank you all for your submissions, and Madam Deputy Registrar, you may now close the proceedings.
Thank you, President Saunders. Thank you, Mr. Justice Witt. Thank you, Mr. Justice Anderson. Thank you, Madam Justice Rochnatlee. And thank you, Mr. Justice Jamada. Thank you, Counsel. And thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.